Senator Head.
Thank you, Mr. Chairman. Thank you, members of the committee, for considering this bill. This bill deals with an animal that's often been called non-recourse civil funding, which is an awkward name, and I'd like to explain why we call it that. The bill contemplates a situation where someone has been injured, for instance, say in a car wreck, and they're the breadwinner of the family, and they can't work. And while their lawsuit is pending, before it is resolved, they need money to pay the mortgage, they need money to pay the utilities, to buy groceries, etc., and need somewhere to turn.
Senator Head, let me interrupt you 1 second. This bill has been heard in this committee before, is that correct?
I know it's been heard in this body before. I don't remember if it was your committee or if it was Senator Steele's. I know it's been heard in
Even
Senator
if it was
Steele's
this committee,
at some point before.
there are some
Maybe
new members
this one as
here.
well.
Has this bill, something similar to this bill, passed the Senate in the past? I think it has, but
Did it?
I think it has, yeah. So it's not really a new,
Right,
whole new
not a new
concept
thing.
coming to us today. I just wanted to get that out there.
Right.
Go ahead,
The
Senator Head.
issue with the bill deals with the fact that it's non-recourse, meaning that when these companies offer money to someone, they say if you win your suit, then you have to pay us out of the proceeds of what you win. Sometimes these people lose their suits, and therefore the company is not owed anything, and that's why it's not called a loan. They don't have to get paid back. They don't get paid back if the plaintiff or if their customer loses their suit. And that's why there are several of these provisions in the bill. I think the bill provides common sense regulation, and some regulation is absolutely necessary. This bill says that they have to write out the contract. The customer has to initial every paragraph in the contract. They have a right to rescind the contract after 5 days. It has to be signed off on by their plaintiff's attorney, and they have to have their opportunity, therefore, to consult with that attorney. And the company cannot interfere with the decision-making or strategy on the suit in any way. There cannot be any referrals or kickbacks, any kind of financial relationship. And the contract, I think most importantly, has to include a payment schedule so that anyone signing this knows exactly what they are doing. They know exactly how much money they will owe after each period of time. And again, because sometimes these companies lose their investment, because sometimes people lose their suits, the rate of interest is going to be higher than what you normally find from a loan on a bank. And then that's necessary in order for this type of practice to be able to continue. It simply can't happen if we don't allow them that higher rate. I think that this is necessary. I think sometimes people do need help. A lot of times lawsuits take way too long to get through the system. And in the meantime, people who are injured have no recourse. So I'm going to ask for your support for the bill. Finally, I want to add that the Secretary of State's office approached me last week. They said they'd like someone else to do whatever regulation the executive branch would have to do. I think as the bill's written, all they would have to do would be to collect money. But I've promised them that I'll find another home in the executive branch for that function, and I intend to do that. So I'll ask that you pass the bill and that we continue to work on it as we move forward. And I'm ready to take your questions and offer up our witnesses. And I would ask Mr. Chairman that Kelly Gilroy testify first.